Hello, everyone. My name is Diane Stevenson. I'm from the UK, from England, and I studied law there. I'm a lawyer, and I'm also a translator and a professor of law. And essentially, my background is that, as I said, I started my legal profession actually working in the House of Lords. I worked in the Judicial Appointments Division of the House of Lords, what was then the House of Lords, now is the Supreme Court. But essentially, part of my role there was helping in the process of the allocation of positions in the judicial system. So it was a very interesting start in the sense of having a good insight into the way the English legal system worked. Once I came to Spain, I started teaching in the Law Society. And from there, I went on to teach in all of the major law firms and then teaching law courses such as English legal courses or contract law and so on in different universities throughout Barcelona. And essentially that's me. I'm the first person or one of the first people that you will meet if you take on this master's program, this postgraduate course, essentially which will give you a wonderful insight into many aspects of law and translation and interpretation. As regards translation, well, I actually started translating when I started to work in the Law Society here, basically because of my legal background and my ability to speak both languages. So I don't have a translation background, but I do have a legal background, and I guess you could say I learned lots of things the hard way. But for many years, I translated for different institutions, also for different bodies of the UN, partly because I did my doctorate course in international public law. So in terms of hands-on experience, I have plenty. I'm not technically orientated, so I'm a human translator. But of course, over the years, you learn different things about different types of translation and systems translations and so on. And today I just wanted to give you a little bit of an insight into the things that we would be looking at on the program to help you sort of essentially get a feel of the material that obviously you would be doing with me. So I'm giving you an extract of one of our first lessons. You have me for 5 sessions, and essentially we look at the English legal system from as many aspects as we can fit in the time that we have. And so I touch on, obviously here you'll see a little bit of the history of the common law, but we also look at procedural law, so criminal law and civil law. We look at the drafting of contracts, we look at tort, we look at business structures, and we look at both. I try to give you an insight both into key terminology, which may or may not be problematic sometimes when we're translating, the joy of false friends from English to Spanish, and obviously from the point of view of substantive law. And I also try to highlight key legal principles that very often are the areas that can lead to confusion or difficulties when we are translating or interpreting. So, well, here we go. Let me give you a little bit of what you'll be seeing. So, as I said, we think about law. What is law? Law is essentially this body of rules and principles that help guide society as to what they can and cannot do. But at the same time, we have a look at the other side of the coin. And if you think about it, it also helps us as individuals know what our rights and obligations are. The same applies for companies and the same applies for states, for example. And depending where you are located, the basis of your legal system is very likely to either be a common law legal system, a civil law legal system, and even a mixed legal system. And it can be mixed between, for example, civil and common law, but it can also be mixed from a religious aspect. So it might have Sharia law, it might have Jewish law, it might have local law based on the history of the country. So as we move forward, we're looking particularly, as I said, at the common law. So one of the first things, just to differentiate between the 2 types of legal systems, you've got one which is adversarial and one which is inquisitorial. Common law is adversarial, meaning that the parties or the representatives of those in the dispute are essentially adversaries, in the sense that they are respectively investigating their cases, and then they go into the courtroom, and before the judge, very often they are the ones that they argue their case. And the role of the judge essentially is to monitor the cases and the trial, and to ensure that the lawyers are using the law and legal principles and interpreting or applying the appropriate interpretation of statute. Now, obviously, in a civil legal system, the lawyers also investigate the case. But the difference here we'll see in terms of adversarial and inquisitorial is the fact that a judge has an inquisitorial role in a civil law legal system. So if you, depending where you're from, you'll work it out later. If you are from a civil law legal system, it's very likely that you'll have heard or you've read cases where judges are asking specific questions, or we're being told that the judge has asked for a certain type of evidence to be introduced or to speak to a number of witnesses and so on. And this just doesn't happen in the common law because the judge does not play that kind of role. So this is where we get these concepts of adversarial versus inquisitorial legal systems. Another thing to bear in mind that when we're talking about the common law, we're talking about England and Wales, not Scotland. This is essentially, as you'll see in a moment, to do from a historic point of view, to do with the fact or the influence of the Romans on these different legal systems. And as you may be aware, the common law is based on something called precedent, and is often referred to as judge-made law. Right? So basically what we're saying here is where in an adversarial system where you have judges not taking such a great role in the actual procedure itself, in terms of, especially in terms of criminal law, and obviously in the trial itself, a judge in a common law system may well lead to or create new law, right? They can't make law as they want. They have obviously restrictions, but at the same time, they do influence and can influence the law in terms of the way in which they apply legal principles and so on. This is seen in today, we see this more clearly through the hierarchy of the courts, something else that we'll be looking at as we go through the course. So essentially the power of different courts on essentially forcing lower courts to actually apply the decisions that they've come to, because these lower courts will be bound to follow the decisions of the higher courts. So just a quick overview, just a visual here. You spot your country, and what you'll see is we'll try to break it down a little bit into, to give you a little bit of an insight into those countries that have different legal systems. So common law legal system, orange, and then you've got civil law system. As you'll notice, I think this is important, in general, a lot of the well-known television programs tend to come from the US, which has a common law legal system. But you'll notice that in reality, the vast majority of countries in some way have been influenced by civil law, right? So the legal systems in those countries are based on civil law. And so that's the reality, even though we see a zillion television programs, I don't know, Suits, CSI, all the variants of CSI, well, lots and lots of programs, whether from the perspective of the police or from the perspective, obviously, of the lawyers, we tend to get bombarded by television programs that highlight certain aspects of a common law legal system. But what I wanted to just quickly point out was that around the world, we've got also systems that are based on Muslim law or have mixed legal systems, okay? And as you'll see, this has a lot to do with history, basically, the extent to which the Romans, upon which civil law is based, because it's also known as Roman law, the Romans were able to essentially, through their conquering of certain countries, especially within Europe, how those countries then went on to conquer or to dominate other countries, and as such instill their own legal system. So this is why we see that spread. So if we go back in time now, I'm going to go way back. So we think, well, what we're doing is just to kind of situate ourselves. So if we think of as I said, the way in which the legal system in England came about. So if we think of, here we're in 1066, right? So as I said, looking far back into history, so prior to the Norman conquest. So what do we have? If we think of the word common in its simplest sense, meaning that it reaches everybody, common is something that you can find everywhere. at this time, English law was not common. So there was no unitary national legal system as we can imagine today, right? What you had, as in most countries at that time, was a vast majority of oral customary rules, right? And obviously this depended on wherever you were in the country, okay? For example, what you had was the Jutes in the south of England, for example, that maybe they essentially you could lose a hand for stealing someone's bread, for example. Whereas in another part of the country, for example, the Mercians in the middle of the country, they may well have put someone in a stockade, right, for doing the same thing, or that you'd be fined, or that you would be whipped, because that's the time that unfortunately that was what would happen at that time. So there were a vast majority of different rules and punishments in the different areas of the country. And as I said, a lot of this was based on oral custom. So I think this is important that we see the distinction between rules that were understood to be the norm, right? What was the custom, and this is what came about by definition of the word custom, through habit, through this constant use, compared to laws that were written. Okay, so depending where you were located around the country, different laws applied. Right? There was, as I said, I vaguely mentioned it, a trial by ordeal. So what you had actually was, if you think of witches of Salem, so essentially, in order to prove your innocence or to prove that you were innocent, very often there were what were called trials by ordeal. So essentially, someone would be, I don't know, they would be tarred and feathered. So they would be covered in tar, and then they would have feathers stuck onto them. And if they survived, then technically they were innocent. But as with the witches of Salem, very often what happened is that if someone believed you to be, or was suspicious as to whether or not you were, for example, a witch, or this time a murderer or a thief, they might well put you inside a barrel, for example, and throw you into the river and see whether or not you drowned. Now, as you can imagine, the downside of not drowning was that you were probably possessed by the devil. And as such, you didn't have a happy outcome. So not the best means of justice, I can say that, to say the least. So again, this leads us to having different courts, local courts around the country, basically applying the law in relation to or in accordance with the local customs. And there was a vast majority of those. So wasn't great for citizens, as you can imagine, because there was no clarity. And at the same time, very often the potential, especially in terms of criminal law, the actual means by which you were put on trial very often did not help if you were found to be innocent. So not the best system, all told. Then basically 1066 to 1150, got a very potted history here, as you can imagine. Thinking about the court system. Essentially you had the king, who was the be-all and the end-all, right? The king was essentially the law, okay? So you had the court of the king. At this time, it was a king and not a queen. Excuse me. Then you had local courts. Then they remained from the Anglo-Saxon period. And these basically, there was a county courts presided over by sheriffs. And it was the sheriffs that actually went around and collected the monies. Now here, the money. And these coins, this money, technically should have gone to the king, but this was not always the case, because very often the money was kept by the lord, first the sheriff, and then the sheriff would give it to the lord of that particular area, right? So what you had is hundreds of courts around the country that dealt with local matters based on local custom, right? And these were monitored by the different heads of families around the country, okay? And so these feudal courts, they basically disputed justice or distributed justice based, as I said, on this local custom, but really very much as they thought was appropriate. And it was the feudal lord who kind of monitored. So you've got the king who, yes, the king was essentially the law. The problem was that to a certain extent, due to the fact that around the country you had all these differences, and the king didn't always have a say as to the way in which decisions were taken, and also the way in which or where the money from these court cases lay. And then at the same time, you had ecclesiastical churches, basically Catholic Church courts. So these also were governed by the laws and principles of the Bible, essentially, leading to this concept of, which we'll look at a little bit during this short talk, of equity, but fairness. So it wasn't exactly the same, but this idea of distilling justice based on the principles of goodness, essentially. And then 1154, more or less, again, I told you, potted history, you have the institutionalization of the common law. And what you have actually is, in relation to what I was explaining, is you have the present king, or the king at the time, Henry II, and essentially Henry II was dealing with the situation of the laws being so different around the country, and the fact, which is also an important element, I think, to consider, the fact that because the sheriffs were giving the money from the court processes to the feudal lords, this very often meant that the king didn't receive all the monies that they were supposed to. Excuse me a moment. And essentially, the goal here was to try to give the king more power, because he was trying to ensure that those in power around the country did not overthrow him, did not take his money, and essentially that in reality, he really was that point of reference when it came to the law, okay? So over time, what you had was the creation of a unified system of law, okay? So you have local courts becoming part of a central court. We subsequently get a jury system and so on. So basically what happened was, in its simplest sense, essentially we could say that there was a clear understanding of the need for the king's representatives to become involved in the legal processes around the country, okay? So essentially what they did was put together, you imagine this, you imagine individuals, very often knights, going around the country on their horses and beginning to listen and then subsequently participate in legal processes around the country, right? So we go slowly from the local application of law to a more centralized application of law. So these traveling judges, again, on the horses, they formed this group, this body of judges that had a national jurisdiction, right? So they didn't have that local connection, as it were. So what we slowly see, and again, potted history, what we slowly see is essentially the movement away from the power being in the hand or being local, or in the hands of the local lords, to slowly being put back into the hands through the king's judges, into the hands of the king, okay? So you had these different areas around the country that these individuals, initially individual judges, would go to specific areas and listen in on those local cases. And they began to understand what type of punishment or remedy, so one punishment, we're talking about criminal law, remedy, we're talking about civil law, would be given in any particular moment, okay? So we developed what are called circuits, which actually still stand today, right? So the circuits is essentially the area where a particular court would belong to. So these judges would travel from London, and then they would go to that particular area, and they began to sit in on the cases. So they heard the pleas in those major places they visited, basically, and they slowly took over the work of the local courts. So the justices that were based in Westminster, actually the Westminster courts, also heard cases over time, right? So as you can imagine, this slowly means that, as imagine you and I, we are moving around the country, we slowly settle, let's say, on one particular area, that becomes our area. So I have mine and you have yours. And we begin to move away from applying a local punishment or remedy to applying a common remedy or punishment. So that I know that whatever I decide is the punishment for theft or different types of theft, you are going to apply the same, right? This obviously took time, okay, potted history. But it's this idea of the judges going out on their horses, going around the country, becoming responsible for a certain circuit, going back and forth between that locality to Westminster, sharing what we've heard and what we've seen, and slowly developing a set of rules and principles that apply in certain situations, okay? And the more serious cases, with time, the more serious cases were heard in Westminster, right? So as I said, this means that as time passed, the decisions of these courts came to be recorded and published. So we go from local, oral, local customs to a common written behavior, right, in terms of punishment or remedy. And this is where the concept of precedent comes into play. So it means that you're using an argument and a principle from a case in more than one location. You're saying that I explain to you what happens when someone steals that loaf of bread. We say that this is what's going to happen if it's a loaf of bread, if it's an animal, if it's a sheep, if it's a dog, if someone breaks into someone's house, if someone, I don't know, punches someone, if someone doesn't pay for what they brought and so on. We determine essentially what should happen. And by that, we create law based upon cases. So we have case law, right? Judge-made law called precedents, right? Now, initially, these cases, as you can imagine, they were persuasive in the sense that if I had made a decision and two of our colleagues had made a decision and they were very similar, or that I argue that in these circumstances, it makes sense for this to happen, slowly, we're going to use that and say, well, yeah, that's a persuasive authority. It makes sense for us to do this because the situation is so similar, right? But as the law and the courts developed, these decisions became binding, meaning that in a given situation, if the facts were sufficiently similar, not the same, as we'll see later, but sufficiently similar, it meant that the court had to apply what had been decided in a previous case, okay? So I think this is really important, that we begin to think about that concept of the way in which we move from local, let's say, to common. And as a consequence, because human nature is what it is, and because people tend to do the same things in similar ways, it meant that we could say in certain situations, we are going to cite this case. We're going to say that there was a case in the north of England or with Judge Diane or Judge Miguel or Judge Maria. And we are going to use that case to support our argument. And as I said, it went from being persuasive to you got to do it. Okay, it's binding. And that is essentially the basic element of change within the legal system in England that led to the common law. So we move from being able to make decisions as we want, let's say, depending on our locality, to a system where judges develop the law and legal principles or actions should be taken in certain circumstances. Right, so we have, as I said, creation of a King's Court and King's Peace. So we have the change of jurisdiction. King's Peace is essentially the king presiding over the land and making decisions, right? So as I said, going from that local decision-making process to the king through his judges, through his court, doing the same, okay? And going back to the Catholic Church, to the courts of chancery, which we'll again look at in a moment, but just to bring that in here, there's also an understanding of the power of a type of church that helps individuals find remedies, find solutions to their problem, not only based on money owned or having to fulfill a contract, but basically about fairness, right? So you have common law courts, but at the same time you had the courts of chancery, okay? So under this legal system, this new legal system, came through a writ, this idea of a writ, especially in the civil law, okay? And we still have them today. So a writ basically is a written document, right? So it's an order issued normally by a court or a body that has administrative or judicial jurisdiction, I would say, and telling you to do something. So it might be an order telling you to give back, I don't know, the cow, or to allow the people to let the cow graze on your land, for which they've been doing so for the last, I don't know, 60 years, right? So it orders the person or entity is addressed to carry out or stop performing specific action, okay? So this was a way through that process, through the writ process, individuals, their problems or their disputes were answered, right? So this was the order from the court normally. Nowadays, we tend to see it as a warrant or a subpoena, okay? Or some kind of order through the court, okay? Actually, in the US, we have a writ of habeas corpus, right? So this is in a situation where the way in which, or the charge under which an individual has been detained may well be seen as being unlawful, right? So you go through this court procedure to help determine whether or not that individual, the defendant, should be released or not, okay? But the system was a writ system. Excuse me. So when we think about judges, if you bear in mind, I said, got common law, and we can also call it law based on precedents, and also have judge-made law. So again, right at the beginning, if you throw your mind back, I made that distinction between an adversarial system and an inquisitorial system, right? So the foundation or that difference between the two systems is very much in the power, let's say, of the judge, or the lack of power, depending on how you want to look at it, of the judge in the respective processes, right? So I think it's important to remember that even though in the common law, a judge can help make law or can lead to the amendment or modification of a law, or introduce, let's say, or yes, introduce a legal principle, the judges are not able to make decisions without taking a primary source of law, which is legislation, obviously, into consideration. So as you can imagine, the majority of times, judges don't make law. The majority of times, the majority of cases are heard in the lower courts. If we're talking about civil law, it's a counter court. If we're talking about criminal law, it's the magistrate's court. 90% of cases in both sides are heard there. Majority of time, they're not mass murders. It's you know, small criminal acts or small civil wrongs, and the cases begin and end there. However, this might there might be a situation where not only is there a dispute as to an action, but it might also be whether or not we can actually move forward in a dispute because of the way in which a piece of legislation is written. So the basic rule is that the judge has to adhere to, has to follow what's been laid down in a piece of law, a piece of legislation, in a law, in a statute, or the same thing, okay? So as I said, they are bound to follow this. However, in situations where the way in which that statute was written was not clear, or because this might arise because of the meaning of a word, for example, if a piece of legislation was written in the 1800s, this well may lead to problems, right, 2022. If we think of the word, just as something as simple as just one moment, stop, and just very quickly think of how you would define the word vehicle. Great. So a vehicle, what's a vehicle? Now, for a law that was written in the 1800s, or early 1800s, let's say, at that time, could have been a horse and carriage. But I'd imagine, easy to imagine, not a scooter, not a motorized scooter, for sure. And is a wheelchair, for example, a vehicle? What kind of bus? Were there buses then? What kind of bus? Are we talking about buses? Are we talking about coaches? So if a vehicle, if it says vehicles are prohibited from the park, does that mean there's no skateboarding? Does it mean we can't cycle? What does the word vehicle mean? So sometimes a judge has to interpret the meaning of a statute. Now, there are guides of interpretation, rules of interpretation. And so again, the judge can't do what they want just because they want to. So there are some basic principles which we'll look at in class to help a judge interpret the meaning behind the statute, meaning of a word, for example. So as I said, it's not freehand, right? So judges, again, they are bound by certain restrictions, and they have to, they're not there in saying, okay, this law doesn't make sense, so I'm going to change it. No. And this legal principle, well, we need to change it just because. No, right? It's a lot more complicated than that. And as I said, the vast majority of cases are heard and finished in the courts of first instance. So as I said, if Parliament legislates a particular area which is already covered by case law, the actual statute takes precedence over the case law. Okay, so legislation is a primary source of law. So I think sometimes there's a little bit of confusion, because we tend to think that a civil legal system, a case based on codes, it's based on statutes. Judges are much more restricted in some respects, as for example, regarding making law, but as it's an inquisitorial system, you'll find that judges take a much stronger role in the actual process compared to in common law. But it doesn't, in both cases, it doesn't mean that there aren't cases, there's not case law in civil legal systems, and it doesn't mean, most definitely not, that there isn't statutes and the judges aren't bound to follow statute in a common law system, right? So in terms of moving forward in the development of the common law, we've got civil law, contracts and torts, right? So the law is developed through case law regarding these different areas, for example, and obviously the same happens with criminal law. So very often, this is very often in class, you'll hear me talk about the chicken and the egg, in the sense that depending on the legal system we're looking at, very often we'll find that a lot of the principles are quite similar. There might be a little tweak here and a tweak there, but the basic principles are the same. Now, some, those from a civil legal system, those based on a civil legal system, will have come about because lawmakers drafted the code, drafted a statute to cover that particular area of law. Under common law systems in England, very often this came about because of a case. So that legal principle came about as a result of a decision of a case. I often try to get you to think that at the end of the day, geographically speaking, countries very often develop at similar paces. And that often means that even if it's legal system are different, so you've got a common law legal system versus a civil law legal system, in terms of social development and legal development, ideas come about at the same time. Principles get developed at a very similar rate. So it's not surprising that you do find these similarities. Give me a second. So we think of the doctrine of precedent. So as I've mentioned, it means that when you're deciding a case in common law, the judge doesn't just look at earlier decisions of judges in similar cases for some kind of guidance. It means actually that they are bound to follow, they have to follow, right, the law that was decided by those earlier cases, right? So if that case was heard in a court that is superior to you, you are bound essentially to follow what was decided. So if we go from the top, we have the Supreme Court, for example. Logically, the Supreme Court binds all the courts below it. And just very quickly, just for you to think about it either way, if we start at the bottom, those courts that I'd mentioned before, the courts of first instance, so that would be civil law, county court, and magistrates in criminal law. These courts that hear the majority of the cases cannot actually create binding precedent. So I also think it's important that you bear that in mind. Again, because television is wonderful, but the reality is that law is slow moving. And very often the legal principles are around for a long time. In general, it's a way of ensuring continuity in law. Sometimes it can be criticized because it also means that the law doesn't move with the times, as it were. But the hierarchy of the courts helps us contain and put into practice the importance of precedents in the common law legal systems. So if you think of it in terms of a case, so not all cases, as I've said, the vast majority are not precedents, but basically it's a decision that we can use, that we can cite, that we can quote as some kind of example or an analogy to try to resolve a case before us that has a similar question of law, okay? So this is very much tied into a concept called stare decisis, based on Latin, which is essentially stand by what was decided. So it makes sense, right? So you're saying that this court has created a legal principle and those courts below it are bound to follow it, okay? And what are we doing? We are standing by what was already decided. Now, in relation to the judge very often, if we're talking about criminal law, remember, it's not the judge, it's the jury that makes a decision as to innocence or guilt, but it is the judge that issues a sentence. And in those higher courts, which in this case would be the Supreme Court, for example, and the Court of Appeal, when the judge is trying to determine this particular question of law or whether or not the decision earlier was correct, they will come and they will give a judgment. And if we, in simple terms, if we think about what is said by the judge, we could break it down into two elements. Ratio decidendi, which is the reasoning or the rationale of the decision given by that judge, and which is subsequently binding. And then you also have the obiter dicta, and it simplest translation or interpretation of this concept is this expression is said in passing or by the way. So if you think of it like this, look, we have a main argument, and that's our ratio. That's the foundation of our reasoning. But to get there, we need to give examples. We need to cite other cases. We need to say what if, how, when, why. If we look at all of those things can be seen as the obiter, right? That's the obiter dicta. So it's everything that's said by the way, everything that's said that is additional to the ratio, right? And very often the way I look at it is we have the obiter that leads us to our ratio. Unfortunately, in case law, the ratio decidendi isn't always very nicely put together so that it's easiest for us to find. But if it's an important enough case, normally the judge makes very clear statements so you can find their ratio, right? As I've mentioned before, historically speaking, you used to have persuasive authority versus binding authority. But if it's a decision that is taken in a higher court and it creates law, then it has to be followed by those in lower courts. One could say that, for example, that let's say common law jurisdiction. So easiest one is to take England, for example, versus the States. So a decision from England may well be cited in a court in the US, but that would be persuasive authority because it's from another country, it's another jurisdiction. If we're talking about the same court structure, then again, thinking of the hierarchy of the courts, those in a higher position, Supreme Court, Court of Appeal, for example, High Court, Crown Court, they can create precedent and their decisions are binding on the courts that are below them, okay? Now, a court can overrule a decision or it could distinguish, right? So it might overrule quite simply in terms of hierarchy. Overrule, if I take a case to the Court of Appeal, for example, so I'm in a lower court, again, if it's criminal law, it would be the Crown Court, and if it was civil law, it would be the High Court. Excuse me. It means that if I make an appeal, let's say it's a criminal case, so if I make an appeal from the Crown Court to the criminal division of the Court of Appeal, if the Court of Appeal decides that the decision in the lower court was incorrect, it is overruling, okay? Now, sometimes, not used very often, but the one mechanism a judge might have to say, I don't have to follow a particular case, is to distinguish the case before him or her with a case that could arguably be seen as a precedent. R&R, case from 1992, we'll look at that when we do our sessions. But essentially, it's a very important case because it basically changed the law. It changed the law regarding the possibility of charging a spouse, in this context a man, with raping his wife. This is to do with history. This is not a moral question. This is more to do with the fact that under the law, English law, from a historic point of view, it was not possible to bring this charge, right? So it's looking at the interpretation of the judge regarding the position of women and men in society in the 1990s and whether or not we could use a law that had been written in the 17th century, okay? Again, we'll look at that in class. So let's go back. When can we use precedent? If the facts are sufficiently similar, so the facts of the case are sufficiently similar, not the same, sufficiently similar. The decision forms part of the ratio decidendi. Okay, so it's the ratio decidendi that makes the case binding. And the court that binds the court which made the decision binds the court that subsequently the case that we're seeing is hearing it. Okay, So we're saying that essentially, if there's a case in, let's say, let's not use the higher courts, let's say, again, stay with criminal, in the Crown Court, okay? So the Crown Court can make precedent. If there's a case in the Magistrates Court that is sufficiently similar in facts to a case that was already taken, a decision that was already made, then the Magistrates Court is bound to follow it, okay? Obviously, we're going to be looking at the ratio of the judge, see how they laid down the legal principles and the reasoning for their arguments, for their decision, I should say. And obviously, key element here is the facts of the case are sufficiently similar. So we're going to have a look at an example, see if we can shed a little bit more light. Got Donahue and Stevenson, okay? Here we're concerned basically with an area of law. If we look at the general definition, the body of law which allows an injured person to obtain compensation from the person who caused the injury. Compensation for the injury suffered. It could be physical, it could be psychological, right? A negligent or intentional civil wrong not arising out of contract or statute. Now, this is a key element. This is the legal definition, and I want you to pay close attention to that first sentence. A negligent or intentional civil wrong not arising out of contract or statute. What does it mean? It means that this individual essentially suffers a wrong, a civil wrong, not as a result. So it's not a case that is going to be based on contract, and it's also something that is not covered by a statute, okay? So this, we're looking here at 1932, so this case actually went, at that time it was called the House of Lords, now it's called the Supreme Court. So this case is a precedent. It's one of the first cases that you learn when you study law, okay? Basically, because it helps you understand precedent. And then we look at it again when we look at contracts, but essentially, it's a very well-known case. It's a case of, we might find it as the snail case, right? Because as I said, it's a key element to understanding the principles that are raised in it. Is the let's say the star of the show is a snail. Right, so why are we looking at the Bible here? Because it's also called the neighbor principle, right? So essentially what you have here, we'll go back, I'll tell you the story. So you imagine that you go out with some friends, right? And your friend offers to buy you a drink. In this particular case, we have an individual that goes out with her friend, and her friend buys her a drink. And they are drinking from a bottle that you cannot see inside, right? So I think that's very important. So if you think of, those opaque bottles that are dark, so you can't quite see into, the bottle, right? They're chatting, they're talking. And as we get to the end of that bottle, it becomes discovered that there was a decomposing snail inside, okay? Now, I'd imagine if I asked you the question, who can bring a claim? Who could sue? You'd answer, the person who drank the drink, or the person who brought the drink. Who would you sue? Would you sue the bar that had sold you the drink? Would you sue the manufacturers? I don't know. You'll tell me when I see you. But if we go back, right, and we take a look, I've lost the definition. Okay. A negligent or intentional civil wrong not arising out of contract or statute. This is really important because we're in 1932. We live in a time when we know that we have certain rights. We know that our rights are protected by, let's say, guarantee, or we understand, even if we don't know what the law is in our respective countries, and for me, it would be the Sale of Goods Act 1979. So I know that if I purchase an item, that it has to be, goods have to be fit for their purpose, right? So irrespective of a guarantee or not, I know that I'm protected under statute by a law that says that when I purchase something, if I open it, it should work. You know, if I open it, take it out of the box and I turn it on, it should work. And when I open the box, it shouldn't be broken, and I'll take it back. Even if I don't have a physical guarantee, or I don't have, technically a guarantee under European law, if the goods are not fit for its purpose, then I have a right to have my money back or for it to be replaced. But in 1932, basically your protection came about from the fact that you had a contract, so that you'd entered into a contractual relationship, or that there was a law, a statute, that protected you. The problem is that Ms. Donahue didn't have a statute that protected her, and she hadn't brought the drink. So at that time, not today, today we wouldn't care about that. But at 1932, consumer protection basically didn't exist. And what you had was a situation in which an individual that suffered a wrong, an injury in civil law, that had not, in this context, had not bought the item themselves, and at the same time was not covered by statute, didn't have protection, right? So this case essentially changed the law. The judge in this case and his reasoning helped, we could say, bring in this concept of consumer protection, but it also created protection for let's say, the final buyer, right? Sorry, the final user, in the sense that it meant that it didn't matter that you didn't buy it, so you had no contract. It didn't matter that there wasn't a statute that protected you. You had a case, because it became a precedent that did protect you. So this is where this comes in. Love thy neighbor. So the judge basically, at the time, people still went to church a great deal, and they knew their Bible. So he used the Bible as the basis of his ratio decidendi, arguing that throughout, or developing it, because throughout the Bible, New and Old Testament, this idea or this understanding that whatever we do, we are supposed to love thy neighbor as we love ourselves. So we'll find it in the New and the Old Testament that we see this constantly, but thou shalt love thy neighbor as they love themselves. One that we know most people have heard in some form, thou shalt not commit adultery, thou shalt not kill, and so on, ends with, thou shalt love thy neighbor as they love themselves, as love your neighbor as you love yourself, as thyself, okay? So we see this throughout. So basically, the neighbor principle used this, or the judge created or developed his legal argument around this concept to try and help people understand, what was he thinking? What was he seeing in this particular situation? So I'll just read this to you. There must be, and is, some general conception of relations giving rise to a duty of care, of which the particular cases found in the books are but instances. The rule that you are to love your neighbor becomes in law, you must not injure your neighbor. And the lawyer's question, who's my neighbor, receives a restricted reply. So at the time, as he said, you needed to have a contract, or there had to be a piece of legislation that protected you. And in this case, there wasn't. So the end user didn't have any protection. You must take reasonable care to avoid acts or omissions which you can reasonably foresee would be likely to injure your neighbor. So foreseeability. Who, then in law, is my neighbor? The answer seems to be persons who are so closely and directly affected by my act that I ought reasonably to have them in contemplation, as long as so affected when I'm directing my mind to the acts or omissions that are called in question. So basically the judge was saying, look, in this context of manufacturing, you've manufactured a product. If you look into the future and you ask yourself, who could suffer injury from my product? You don't automatically think of the person who brought it as if only of the person who brought it, because you're well aware that people buy things for someone else, especially drinks. So what he argues is that you have to look forward and take any steps, whether a positive action or a negative action, to ensure that that person doesn't suffer from your act, your omission, for example. So what we're looking at is negligence, essentially. So he's arguing about this concept of a duty of care to the final consumer, not based on contract and not relying or waiting for a piece of legislation to protect you, right? So this, as you can imagine, 1932 changed the law. This judge helped create law that subsequently may well have been put into a statute. But this case is the legal principle upon which someone at that time could use or go to if they were in a similar situation. So just very quickly, you've got Grant and Australian Knitting Mills, 1936, right? This time we're talking about the Court of Appeal, not the House of Lords. And we're in Australia, not in England. But I'll just bring this in here to help you see. Now, in reality, this might seem like a very different case. What you have is a gentleman who was given a pair of undergarments, basically. And this undergarment, he's in Australia, so it's like arms, it's like inside little bodysuit. And essentially, these undergarments were made of wool. and it's natural wool, and this natural wool had to be treated, was treated with a chemical compound, right? Unfortunately, the chemicals weren't washed out properly, and that led to him getting a terrible, terrible rash. And basically he went to court to try to find a remedy. But in Australia at the time, we had a similar issue, that because he hadn't brought them himself, there was no contract, and there wasn't a statute that protected him. So even though this case, I've done here in Stevenson, took place in England, his lawyers used this case, this principle was applied from England, okay, saying that, what do we have? Now, it seems like very different. We're talking about a drink compared to undergarment, but what is similar here? We see we are in a situation where the person who suffers the injury didn't make the purchase. It's not based on contract. There's no law that protects them. The damage was done by something that you couldn't see. And one, it's a snail, and the other, it's basically chemicals. And that final consumer is the one that suffered, basically. So as I said, it was independent of a question of contract. And so the courts there in Australia, because at the time it was a Commonwealth, were able to apply that case to, in the Court of Appeal, they applied the case from the House of Lords in England, right? And actually was binding authority because of the relationship between England and Australia at the time. But as I said, if it was now, then it would be persuasive authority. Okay? So I think it's important for you to sort of let that sit a little bit and hopefully see that connection. We will look more into the way in which judges can interpret statutes and to better understand legal principles and examples of precedents, and you'll be practicing your abilities to interpret the law yourselves. So just to finish off, I just want to leave you with a little a thought, a seed, right? I'm not sure if you understand or if you're aware of the concept of the burden of proof, right? But one thing, this is a sort of core element of whether we're talking about criminal procedure or civil procedure. So, and that's why we have these differences. So if we talk about criminal law, the state is under the obligation to prove beyond a reasonable doubt that the defendant, the person that's charged, is guilty. Now, this is because this burden of proof is much heavier in criminal law because of the fact that an individual may well end up in prison and lose their liberty. Comparatively, in civil law, it is upon the claimant, on a balance of probabilities, we're talking about the US, on a preponderance of the evidence, to show that the person that they are suing, the defendant, is liable. So criminal law, we talk about guilt. So I wanted to bring that in here just as to leave you with that, because sometimes terminology, we get confused. Guilt, criminal law, liability, civil law, okay? Different burdens of proof, right? Weight is much higher in criminal law, and in civil law on a balance of probabilities. So if you think about, if you have car insurance, for example, or house insurance, you're aware that you may have full insurance, third-party insurance. So there's an understanding that you don't always have 100%. So in civil law, I would say that there's an understanding that 45%, 50% liability is possible. Doesn't have to be 70%, doesn't have to be 90%. In criminal law, there's a much greater burden because of the consequences. And just, as I said, I wanted to leave you with this case, which we'll look at again, which we'll talk about if you end up doing the course. So really, O.J. Simpson case for me is one of those cases. One, it's incredibly interesting from the point of view of criminal procedure, of the way in which a jury is chosen from an American perspective, common law perspective, but in America, the times we are accustomed to reality TV, but this was the beginning of reality TV for many. Okay, so imagine what life would have been like if you didn't have access to all the types of information online. That there are only 5 television channels, and that every day you were seeing a case. And I bring this here, or I leave you with this, is because this burden of proof, proving beyond a reasonable doubt, and proving on a balance of probabilities that someone is liable, come to the fore in this case. So really it's for you to start thinking about how is it possible that in the same case we have two very different outcomes, and this is because of the burden of proof. So we'll have a delve into the O.J. Simpson case, obviously, to highlight that when we're looking at criminal and civil procedure. But as I said, you've got a case in which the same individual went through a criminal process and through a civil process with very different outcomes. Okay, and so I think it leads or lends itself to help you understand the importance of the role of judges in criminal process and civil process in the common law, the role of the jury, very much so, the importance of evidence and the way in which both the defense and the prosecution can use that. And we come back to it, the importance of the burden of proof. So the question is, how is it possible that O.J. Simpson was acquitted, he was found innocent in the criminal trial, and yet was found liable in the civil trial? Well, hopefully I'll have the chance to explain further once we start the course. I hope this has been interesting for you and that it's helped you have an insight into what to expect should we move forward, should you move forward and take the course. Wishing you all well. Take care, everybody. Goodbye.